Right now, you probably have a hard drive full of designs or illustrations or maybe branding packages that you firmly believe you own. I mean, you built them, right? You exported them. They're yours.
Yeah, that's a natural assumption.
But the second you attach that PDF to an email or, send that pitch deck to a prospective client without fully understanding transfer rights, well, you might be legally locking yourself out of your own artwork.
Well, it happens every single day in this industry. I mean, a designer creates a phenomenal brand asset. They sign some boilerplate agreement they just downloaded off the internet.
Right, without even reading the clauses.
Exactly, without reading it at all. And suddenly, they are legally barred from ever putting that piece in their own public portfolio.
Wow.
Yeah. They essentially build a beautiful house and accidentally hand over the master keys, the deed, the zoning rights, all for the price of a 1-month rental.
It's honestly the ultimate nightmare because we spend years refining our craft, right? Mastering typography, color theory, Bezier curves. But we spend almost zero time learning how to build a legal fence around those assets.
None. Zero.
We just step out into the commercial market completely unarmed. We treat our work like a casual hobby, but the corporations and the clients we're dealing with, they treat it like real estate.
Which is exactly why we need to strip away the intimidation factor of intellectual property law today. Because the concepts aren't actually that complex once you get past the dense legal jargon.
Right.
It is ultimately just about establishing boundaries, claiming ownership, and strategically deciding how you want to monetize your intellectual labor.
Welcome to today's deep dive. If you're listening to this, you are a creative professional. You might be a freelancer navigating your first big corporate contract, or maybe you're an art director who needs to understand exactly what your agency is buying when you commission an illustrator.
And our mission today is to hand you the armor.
Yes, the armor. We are breaking down the absolute core standards of copyright and trademark specifically tailored for designers. Like, we're gonna look at what happens the exact millisecond you create a file, how you prove you own it, and, well, how you lease it out without getting fleeced.
And we are anchoring this entire conversation in a phenomenal foundational resource. It's Chapter 2 of the Graphic Design Reference Plus Specification book.
Such a good book.
It really is a manual that every working designer should have within arm's reach, because it translates these massive federal statutes into practical, everyday operational standards.
So before we start tearing down the misconceptions, and believe me, there are a lot of them, I want to ask you a quick favor. If you want to keep building your professional toolkit, if you want more of these technical design breakdowns and career-building insights, hit that follow button on the show right now.
Absolutely do it.
Consider it an essential tool for your professional growth. The legal and technological landscape of design is shifting faster than ever, and we're here to help you navigate it, so make sure you're following along.
It really is the difference between being a creative who occasionally gets paid and being a professional business owner who commands respect in the marketplace.
Well said. So let's establish the absolute baselines. Let's look at the bedrock of creative protection. Because before you can defend an asset, you have to accurately diagnose what kind of legal entity you've actually brought into the world, right?
Right. You have to know what it is.
And in the design space, we are almost always dealing with two distinct pillars: copyright and trademark. So let's start with copyright. The foundational definition we're working from characterizes copyright as the exclusive legal right to reproduce, publish, and sell a literary, musical, or artistic work.
I want to zoom in on the word exclusive in that definition, because it does an immense amount of heavy lifting in intellectual property law.
Okay, how so?
Well, exclusivity isn't just a vague concept of ownership, It is a highly specific, multi-pronged monopoly granted to you by the government. When you hold a copyright, you hold a ring of keys.
A ring of keys, I like that.
Yeah. You have the key to reproduction, meaning you alone decide if copies can be made. You hold the key to public display. You hold the key to distribution. And perhaps most importantly for designers, you hold the exclusive right to prepare derivative works. Derivative works, okay, that is the one that always sparks massive arguments in agency Slack channels.
Oh, absolutely.
Let's get really concrete here. What constitutes a derivative work? Like, if I create an original character illustration, let's say a highly stylized cyberpunk detective, what does owning the derivative rights actually prevent others from doing?
It prevents anyone else from taking your core expression and adapting it into a new medium or format without your explicit permission.
Wait, they can't make a toy out of it.
Exactly. They cannot take your 2D cyberpunk detective and sculpt a 3D printable miniature of it. They cannot take your character and write a graphic novel featuring them.
They cannot take the specific, distinct vector line art you created and turn it into a repeating pattern for a textile company. You own the root of the tree, which means you fundamentally own every single branch that grows out of it.
But I want to push back on that, or at least find the boundary line. Because if I own the rights to a cyberpunk detective, I obviously don't own the entire genre of cyberpunk, right? Nor do I own the concept of detectives. We have to separate the idea from the execution.
Exactly, and that is the most critical dividing line in all of copyright law. The legal standard is incredibly rigid on this. A specific work can be copyrighted, but an idea absolutely cannot.
Never.
Never. Ideas, concepts, systems, and methods of operation are entirely exempt from copyright protection. If you invent a highly functional new mechanism, you have to look into patent law, which is a brutally rigorous, expensive, and fundamentally different legal arena.
Right. So let's say I'm an agency creative director. I have a brilliant concept for a new beverage campaign. The idea is to photograph athletes mid-sprint, but using a specialized long exposure technique so their sweat looks like glowing neon energy trails.
Okay, cool concept.
Thanks. So I pitch this idea in a boardroom. I don't show them any mock-ups. I just verbally describe the concept. 2 months later, the client goes to a rival agency and they execute that exact idea. Neon sweat, sprinting athletes. Can I sue them for copyright infringement?
No, you will lose that case every single time, and you will likely pay their attorney fees for bringing a frivolous lawsuit.
Ouch.
Yeah. You pitched an idea. Ideas are as free as the oxygen in that boardroom.
So they essentially got free real estate from my brain.
Legally, yes. However, the exact moment you go back to your studio, hire a photographer, set up the lighting, dictate the specific angle, choose the exact neon hex codes in post-production, and export that final JPEG, that execution is your copyrighted work. If the rival agency somehow gets their hands on your specific JPEG file and uses it in their ad, that is blatant copyright infringement.
But what if they don't steal my file? What if they hire their own photographer, use different athletes, shoot from slightly different angles, but clearly use my underlying concept of neon sweat trails?
Then they have successfully mined your unprotectable idea, but they have not infringed on your copyrighted expression. To prove infringement, you have to prove two things: access to your work and substantial similarity.
Substantial similarity.
Right. And substantial similarity applies to the expression, not the concept. If their athletes, lighting, and composition are entirely different, they are legally in the clear. It might be unethical, it might be incredibly shady industry practice, but it is not copyright infringement.
That is a harsh reality for a lot of art directors to swallow, but I guess it makes sense, right? Like, if we could copyright ideas, the first person to paint a bowl of fruit would own the exclusive rights to still life paintings forever. Culture would stagnate immediately.
Precisely. Copyright is designed to balance the protection of the creator with the enrichment of the public domain.
Okay, so copyright protects the artistic execution, the photograph, the illustration, the underlying code of a website. But as designers, we don't just make art in a vacuum.
No, we definitely don't.
We aren't just sitting in garrets painting for ourselves. We are commercial artists. We build brand identities. We design logos, packaging, corporate systems, and that requires an entirely different set of legal armor, right? Trademarks and service marks.
Yes. If copyright protects the specific artistic asset, trademark protects the commercial identity. The operational definition of a trademark is a word, phrase, symbol, or design that distinguishes the source of a product from one originator to another.
Distinguishes the source. That is the phrase we really need to unpack, because it sounds a bit academic, but it is actually the entire psychological foundation of consumer capitalism.
It really is. Think about it purely from the perspective of consumer trust. Let's look at the fashion industry, specifically footwear. If you see a woman walking down the street in a pair of black stilettos, they're just shoes. But the second she lifts her foot and you see that the entire outsole is painted a highly specific, glossy, vibrant red gate, you instantly know exactly who designed that shoe.
Oh, Christian Louboutin.
Exactly. You know it's Louboutin, you know it's a luxury item, you know roughly what it costs, you don't need to see a logo, you don't need to read a label. That specific red sole distinguishes the source of the product.
And Louboutin famously fought a massive multi-year legal battle against Yves Saint Laurent to protect that exact trademark. YSL made a monochromatic red shoe, and Louboutin sued them.
Yes, and the nuances of that case perfectly illustrate how trademark works. The courts ultimately ruled that lubritant does hold a valid trademark for a red outsole, because over decades of marketing, that color had acquired secondary meaning in the minds of consumers.
Meaning when people see the red sole, they don't just see the color red, they see the brand.
Yes, exactly. However, the court also said Louboutin cannot prevent competitors from making a shoe that is entirely red from top to bottom. The trademark specifically protects the contrast of the red sole against a different colored upper shoe.
Wow, that is incredibly granular. But it highlights the core purpose of a trademark. It isn't about owning a color or owning a word. It is about preventing consumer confusion.
Exactly. And to cover our bases, we should note that a service mark is the exact same legal concept, but applied to services rather than physical goods.
It's like an airline.
Yeah, or think about streaming. When you hear that specific two-note ta-dum sound when you open Netflix, that audio chime is a registered service mark. It distinguishes the source of their streaming service from Hulu or HBO.
So here's the intersection that designers constantly find themselves trapped in. We create assets that function as both a copyright and a trademark simultaneously.
All the time. Let's say you design a highly illustrative, intricate mascot for a new chain of coffee shops. It's beautifully rendered illustration of, let's say, a caffeinated owl.
Okay, so as the creator of that illustration, I own the copyright to the specific drawing of the owl. I control the reproduction of that art.
Yes, but the moment the coffee shop takes your owl illustration and puts it on their storefront signage, prints it on thousands of disposable cups, and embroiders it on their barista aprons, that illustration is doing a second job.
It becomes the face of the business.
Right. It has become a brand identifier. It is now a trademark, or technically, a service mark for the coffee shop.
And understanding which legal framework applies dictates how you enforce your rights. Let's say another coffee shop opens up in the next state. They don't download my exact owl illustration file, so they aren't committing copyright infringement.
Right, no copying of the file itself.
Instead, they hire a different illustrator to draw a completely different looking owl, but they use the exact same color palette, they use the same typography for their menu, and they call their shop the Caffeinated Owl.
That is trademark infringement, clear as day. Even though they didn't violate your copyright by copying your specific art file, they are mimicking the overall brand identity.
Because of the confusion.
Exactly. The legal test is simple. Would a reasonable consumer walking down the street be confused? Might they walk into that new shop thinking, oh, this must be a new location of that owl coffee place I love? If the answer is yes, they are misleading the public and damaging the original brand's goodwill.
So as a professional designer, you have to be bilingual. You have to speak copyright to protect the intrinsic value of your art, and you have to speak trademark to protect the commercial value of the identities you build for your clients.
Exactly right.
But knowing the definitions is really only half the battle. How do we actually activate these shields? Because there's a massive difference between having a theoretical right and having an enforceable reality.
Which brings us to the timeline of protection. The transition from the magic of creation to the hard reality of registration and enforcement.
I want to start with a concept that I think is wildly misunderstood by beginners, but is deeply empowering once you actually grasp it. It's the moment of creation rule.
Oh, it's the bedrock of modern international copyright law, heavily influenced by agreements like the Berne Convention. The rule states that anything produced is a copyrighted piece of work as soon as it is produced.
So there's no waiting period. I don't have to mail anything to myself, which, by the way, we should probably debunk right now. The whole poor man's copyright thing where you mail a sealed envelope of your sketches to yourself to prove the date.
Oh, it's a complete myth. Please don't do that. It holds virtually zero weight in modern federal court.
Really?
Really. The postmark on an envelope does not establish a legal copyright. The law is much simpler. The millisecond you affix your original expression into a tangible medium, whether that is ink on paper, clay in a mold, or pixels saved to a hard drive, that work is fully protected under U.S. copyright law.
Assuming it meets the very low bar of being original and possessing a modicum of creativity, right?
Correct.
And how long does this automatic, instantaneous force field actually last? Because historically, it used to be much shorter.
Historically, yes, you had to actively renew it. But today, it is a generational timeline. In the United States, for works created by an individual, the copyright endures for the author's entire lifetime, plus an additional 70 years after their death.
Lifetime plus 70 years. I want you, the listener, to really absorb that. If you design a brilliant poster today and you live for another 50 years, that specific design is protected for 120 years. Your children, and potentially your grandchildren, will hold the exclusive rights to license, reproduce, or monetize that asset long after you are gone.
It's powerful.
You aren't just creating a deliverable for a client, you are literally minting a generational asset.
Which is precisely why major entertainment corporations lobby so aggressively to extend these terms. The 70-year rule was heavily influenced by the Sonny Bono Copyright Term Extension Act, often jokingly called the Mickey Mouse Protection Act, because Disney realized their earliest copyrights were about to expire.
Right, they had to protect the mouse.
Exactly. They understood that these assets have immense compounding value over time. Independent designers need to view their own work with that exact same level of long-term commercial respect.
But this introduces a massive logical contradiction that just drives me crazy. If the protection is genuinely automatic, if the federal government acknowledges that the art is mine the absolute second I hit save as, why on earth do I need to ruin my pristine, perfectly balanced composition by slapping a clunky copyright symbol in the bottom corner?
I hear that complaint a lot.
Like, if the law already knows it's mine, isn't the symbol redundant?
It is legally redundant, yes. Placing a copyright notice, the copyright symbol, the year, and your name is no longer an absolute requirement to maintain your copyright. If you post a drawing on Instagram without a copyright symbol, you do not forfeit your rights.
So why do industry standards strongly suggest we still do it?
Because of the realities of litigation. It is entirely a strategic move to destroy a specific legal defense.
Okay, walk me through that.
Imagine you find your illustration being used on a line of t-shirts sold by a major retailer. You send a cease and desist, and they eventually end up in court. If your original work had no copyright notice on it, the retailer's lawyers will immediately claim innocent infringement.
They will play dumb. They'll tell the judge, Your Honor, our intern found this image on Pinterest. It had no name, no date, no symbol. We genuinely believed it was in the public domain. We had no intent to steal.
Exactly. And if the judge believes them, your potential financial damages can be drastically reduced. The penalty for accidental innocent infringement is much lower than the penalty for willful malicious theft.
I see the trap. So it's about proving intent.
But if you had properly placed copyright 2026 John Doe on that image, you have legally eliminated the excuse of ignorance. The symbol acts as a blatant no trespassing sign on your property line.
It proves they knew.
Yes. You prove to the court that the infringer saw the warning, ignored it, and willfully stole the asset anyway. It makes your case exponentially stronger and significantly increases the financial damages you can recover. For digital works, standard practice is to include it directly in the file metadata. And for web designers, utilizing the HTML entity in the site footer is mandatory baseline behavior.
Okay, so the copyright symbol is a strategic warning sign. Let's pivot to the trademark side, because this is where I see freelancers make catastrophic, highly illegal mistakes. Let's talk about the alphabet soup of trademark symbols. The TM, the SM, and the big, intimidating R inside a circle.
This is a total minefield. Let's establish the common law rights first. The TM symbol stands for trademark, and the SM symbol stands for service mark. The fundamental rule here is that anyone can use the TM or SM symbol to alert the public to their claim of rights, regardless of whether they have filed a single piece of paperwork with the government.
Wait, really? If I design a new logo for my freelance studio today, I can just type a little TM next to it on my website. I don't have to pay a fee. I don't have to register.
You do not. By simply using the mark in commerce, by actually operating your business and using that logo to identify your services to clients, you establish common law trademark rights in your specific geographic area.
That's amazing.
The TM is just you planting your flag. You are announcing to your competitors, I consider this my brand identity. Do not copy it.
That feels almost too easy. So if the TM is free and immediate, why do people care about the R inside the circle, the registered symbol? Can I just use that one instead because it looks more official?
Absolutely not. And this is where designers get themselves into massive legal jeopardy. The federal registration symbol, the R in the circle, can strictly only be used after the United States Patent and Trademark Office, the USPTO, has formally approved and registered your mark.
So I can't use it while I'm waiting for approval because trademark applications can take, 10 to 14 months to process?
Easily. And during that entire waiting period, even if you paid the filing fee and submitted all the perfect specimens of use, you must only use the TM. Using the R prematurely is considered false advertising and fraud.
Wow. Fraud.
Yes. You are publicly claiming a federally protected status that you do not yet possess. If your application is contested, The fact that you misuse the R symbol can actually be used as grounds to deny your registration entirely.
That is a brutal technicality. And there's another limitation on the R symbol, right? It's tied specifically to the goods and services you listed in the application.
Precisely. Let's say you register the mark for your freelance design studio. You are protected in the category of graphic design services. 10 years later, you decide to start manufacturing custom mechanical keyboards under the same brand name.
A natural pivot.
Right, why not? But you cannot just slap your existing registered symbol onto the keyboards. Your federal protection is siloed to the specific industry classes you registered for. You would need to file a brand new application with the USPTO for the keyboard manufacturing class.
Which begs the ultimate question. If I have automatic copyright the moment I create something, and I have common law trademark rights the moment I use a logo, why am I bothering with formal government registration at all? Why am I paying fees, filling out tedious applications, and waiting months?
It's all about enforcement.
Let's take copyright first. Standard registration requires submitting an application, 2 visual representations of the work, and a non-refundable fee. It's $65 for a paper filing, or $35 if you file electronically at copyright.gov. Sell me on why a broke 22-year-old freelance illustrator should spend $35 every time they finish a major piece.
Because without federal registration, your copyright is essentially a paper shield.
Yeah.
Yes, you technically own the rights, but if someone steals your work, what are you actually going to do about it?
I mean, I'd send a cease and desist letter.
And if they ignore it, the only way to actually force them to stop or to force them to pay you for what they stole is to file a lawsuit in federal court. And under U.S. law, you cannot even walk through the doors of a federal courthouse to file a copyright infringement lawsuit unless your work is formally registered with the U.S. Copyright Office.
Oh, so registration is the admission ticket to the courtroom.
Exactly. Furthermore, if you register your work before the infringement occurs or within 3 months of publication, you unlock 2 massive legal weapons: statutory damages and attorney's fees.
Explain statutory damages, because normally if someone steals my illustration and uses it on a flyer, I have to prove exactly how much money I lost, right? Which is really hard to quantify.
It is incredibly difficult and expensive to prove actual financial damages. But if you registered early, the law allows you to claim statutory damages. This means the judge can just look at the infringement and say, the penalty for this is $30,000, regardless how much money you actually lost.
Oh, that's huge.
And crucially, if you win, the infringer has to pay your lawyer's fees.
Which fundamentally changes the negotiation dynamic. Because if I have a registered copyright and a corporation steals my work, I can hire a lawyer on contingency. The lawyer knows they'll get paid by the corporation when we win. If I'm not registered, no lawyer is going to take my case because the potential payout is too low and the burden of proof is too high.
Precisely. That $35 electronic filing fee is the cheapest litigation insurance policy you will ever buy. And thankfully, the effective date of registration is the exact day the Copyright Office receives your complete application, copies, and fee, not the day they finally mail you the certificate months later.
Okay, you sold me on the copyright registration. Now what about trademarks? Applying for a federal trademark with the USPTO costs hundreds of dollars per class of goods, not to mention attorney fees if you hire someone to help. If the TM gives me common law rights, why spend $1,000 getting the registered symbol?
Because common law rights are geographically constrained. If you open a local design agency in Austin, Texas, using a specific TM logo, you only have rights in the Austin area. If someone in Seattle opens an agency with the exact same name and logo, you can't stop them because your common law rights don't reach Washington state.
But the internet exists. My portfolio is global.
Which is exactly why you need federal registration. Federal registration grants you a nationwide presumption of ownership. You own that mark from coast to coast. Second, the registration certificate serves as prima facie evidence in court. You don't have to spend tens of thousands of dollars proving you own the mark. You just hand the judge the certificate.
And there's an international enforcement component too, right? Something involving border control.
Yes, and this is incredibly powerful for designers who create physical products, like apparel designers or packaging experts. When you hold a federal trademark registration, you can record that registration with U.S. Customs and Border Protection.
How does that actually work logistically? Does a border agent look at every t-shirt coming in from overseas?
They use a centralized database called the e-recordation system. You upload your registered trademark, your logo files, and details about your legitimate supply chain. CBP agents at ports of entry use this database to actively monitor shipments.
Wow.
If a shipping container arrives from an overseas manufacturer filled with counterfeit merchandise bearing your exact logo, Customs has the authority to seize and destroy those infringing goods right at the border before they ever enter the U.S. market.
So they act as a massive, heavily armed brand protection agency for your portfolio.
Exactly. You cannot do that with a common law TM. It requires the federal registration.
Okay, so we have established the fortress. We know the difference between the art and the identity. We know how to lock down the automatic rights, and we know when it is strategically necessary to pay the government to reinforce those rights.
Right, the defensive stuff.
But a fortress is ultimately useless if you never open the gates to engage in trade. You can't just hoard your designs, you have to monetize them. How do designers actually license these assets to clients without accidentally giving away the deed to the castle?
This is the most critical survival skill for a freelancer. We need to dissect the mechanics of transfer rights, because the word sell is highly dangerous in this context.
Right. Clients will email you and say, I want to buy this illustration. And young designers assume that means they are selling the physical object and all the associated rights, like selling a used car on Craigslist. You hand over the keys, you take the cash, and you walk away forever.
If you do that, you are engaging in a full transfer of copyright or signing a work-for-hire agreement. And there are times when that is appropriate. If an agency hires you full-time, they own what you create. But as an independent creator, your default posture should be leasing, not selling. You retain the master title and you grant the client specific temporary permissions to use the work.
Let's use a real estate analogy because I think it clarifies the mechanics perfectly. Imagine your copyright is a massive commercial building that you own. You don't want to sell the building. You want to rent out individual office spaces on different floors to different tenants under highly specific lease agreements.
That is the exact correct mindset. And industry standards generally recognize 5 distinct types of these leases or transfer rights. Understand the boundaries of each lease dictates how you price your work. The first is first rights.
First rights. The text defines this as a lease for one use where the work is published for the absolute first time. Why does the timeline matter to the client?
It is about exclusivity and prestige. Imagine a major national publication like Wired or The New Yorker commissions you for a cover illustration. They are paying a massive premium because they want the cultural impact of premiering that image to the world. They want to own the initial conversation.
Right.
If their readers realize that illustration has been sitting on your Instagram for 3 months, it severely diminishes the editorial impact.
So they are renting the grand opening rights to the building, but crucially, once that issue hits the newsstands, their lease expires. The rights revert fully back to me.
Yes, but obviously you can never sell first rights to that specific image ever again. That ship has sailed.
Which brings us to the next tier of leasing, one-time rights.
This is a lease for a single use, but there is no guarantee provided to the buyer that they are the first to publish it.
So a textbook publisher might buy one-time rights to use an infographic I designed 3 years ago. They just need a clear visual to explain a concept. They don't care if it's been seen before. They print their 10,000 copies, and the lease is over.
Exactly, and closely related to that is the third category, reprint rights, sometimes called serial rights.
This is the dream for illustrators. Passive income from past labor. The text defines this as giving the leaser the right to use or publish the work after it has already appeared elsewhere.
It acknowledges and formalizes the secondary market. You sell first rights to a magazine in the US. 6 months later, a magazine in Germany sees it and wants to run it alongside a translated article. You sell them reprint rights. You just got paid twice for the exact same hour of drawing.
Nice.
You rented out the first floor to one tenant, and a month later, you rented out the second floor to another.
Okay, the fourth type of lease is where we start getting into the granular, highly specific operational needs of corporations. Promotion rights.
This is a fascinating legal loophole that has to be explicitly closed in contracts. Promotion rights give the leaser the right to use the work specifically for promotional purposes. And importantly, it is almost always tacked on to another primary lease.
Let's break down why this is necessary. Let's say I license a beautiful botanical illustration to a boutique greeting card company. They are buying the rights to print my flowers on a folded piece of cardstock and sell it in gift shops. That is their primary lease.
Right, but how do they actually sell that card to retailers? Their marketing department needs to run advertisements. They want to buy a full-page ad in a stationary trade magazine, and the ad features a photograph of their new line of cards, which heavily features your botanical illustration.
Oh, If their contract only specified rights to reproduce on greeting cards, they are technically committing copyright infringement by reproducing the image in a magazine ad, even if it's an ad for the card itself.
Precisely. The legal boundaries are that strict. So the company must negotiate a promotion rights clause in the original contract. It explicitly grants them permission to reproduce the artwork in catalogs, social media ads, and trade publications, strictly for the purpose of promoting the specific product they licensed.
It really emphasizes how absolute your monopoly is as the copyright holder. You control every single context in which the pixels appear.
Which leads us to the fifth and final major category, and arguably the most dangerous one if misunderstood: exclusive rights. The standard definition is that the leaser retains the right to use or publish the work exclusively within their specific industry.
The word exclusive terrifies freelancers. They hear exclusive, and they assume it means a total buyout. They assume they're handing over the keys to the entire commercial building.
But they aren't. And this is where the real estate analogy shines. If an agency buys exclusive rights to your illustration for a high-end fashion campaign, they are not buying the building. They are signing an exclusive lease for the high-end retail sector of your building.
They are saying, we will pay you a massive premium, but you legally cannot lease space to any other high-end fashion brand. If I draw a sleek, stylized panther for Gucci, I cannot turn around and license that exact same panther to Prada.
Exactly. You are granting them a monopoly within their competitive market. But UT, and this is the leverage point that designers need to realize, you are only restricted within that specific market.
So I can't sell the panther to Prada, but could I license that exact same panther illustration to a craft brewery in Oregon for their new IPA label?
Yes. Could you license it to a snowboard manufacturer? Yes. Could you license it to a video game studio for a background asset? Yes. You have retained the right to monetize that asset in completely different, non-competing industries.
That's incredible.
A fashion brand gets the exclusivity they need to protect their campaign, and you retain the right to slice the pie in a dozen other directions.
It is a profound shift in mindset. You stop viewing your work as a disposable commodity, and you start managing it like a diversified asset portfolio. But to play devil's advocate, everything we have discussed so far is fundamentally combative. It's about hoarding rights, restricting access, extracting maximum capital, and threatening lawsuits.
Sure.
What if I don't want to operate like a ruthless corporate litigator? What if I'm designing educational tools or open source software UI, and my primary goal is widespread adoption and community collaboration?
That is a highly valid modern strategy, and the strict binary nature of traditional copyright law actually makes that kind of collaboration incredibly difficult. Under default copyright, every single person who wants to share your educational poster on their blog technically needs to email you and negotiate a formal transfer of rights. The friction is immense.
Which brings us to the counterculture of copyright. How do we play nice in the sandbox? We have two primary mechanisms for this: the public domain and Creative Commons. Let's start with the ultimate open sandbox, the public domain.
The public domain is not a license. It is the absence of copyright. When a work enters the public domain, the government monopoly has expired. The work belongs to humanity. The rule is absolute. Works in the public domain can be used by anyone for any purpose, including commercial profit, without obtaining permission or paying a single cent in royalties.
So I can take a high-res scan of Van Gogh's Starry Night, print it on a line of cheap umbrellas, sell them at a massive markup, and the Van Gogh estate cannot stop me.
Correct. The cultural asset has been returned to the commons. But the timeline for when an asset actually crosses that boundary is dictated by strict countdowns.
We mentioned earlier that for accredited work where the author is known, the countdown is the author's lifetime plus 70 years. So practically nothing created by a known designer in the digital age is in the public domain yet. But what about anonymous works or works created by a corporation under a work-for-hire agreement?
For uncredited, anonymous, or pseudonymous works, the generational rule doesn't work because we don't know when the author dies. So the law uses fixed dates. These works lose protection either 95 years from the date of their first publication or 120 years from the date of their creation, whichever expires first.
So if a vintage ad agency created an anonymous logo in 1920, it is likely in the public domain today. But if I am a designer right now in 2026 and I want to release my new icon set to the community today, I can't wait 70 years after I die. I need a mechanism to bypass the default lockdown of copyright right now.
And that exact need birthed Creative Commons. Creative Commons, or CC, is a nonprofit organization that fundamentally revolutionized digital sharing. They provide standardized, free copyright licenses that allow creators to give the public permission to share, use, or build upon their work without fully surrendering it to the public domain.
It replaces the friction of traditional negotiation with an API-like legal framework. It changes the default setting from all rights reserved to some rights reserved.
Exactly. It offers flexibility. You maintain your underlying copyright, but you pre-approve certain uses. The organization has structured this around 6 primary licenses, which act like modular building blocks.
Let's group these conceptually rather than just listing the acronyms, because the strategy behind choosing a license is what actually matters. Let's look at the first group, what I'll call the open ecosystem tier. This includes CC BY, which is attribution, and BYSA, which is attribution share alike.
CC BY is the most accommodating license possible without abandoning the work entirely. It allows anyone to distribute, remix, edit, and build upon your original work. They can chop it up, change the colors, and critically, they can use it for commercial profit.
So a massive tech company could take my CC BY icon set, use it in their paid enterprise software, and make millions of dollars.
Yes, provided they fulfill the single, non-negotiable condition of every CC license. They must explicitly attribute you as the original creator, maximum freedom, mandatory credit.
But if I find that a little too parasitic-like, if I don't want a corporation taking my free work, improving it, and then locking up the improved version behind a paywall, I would use the second license in this tier, attribution share alike.
The share alike clause is a stroke of legal genius. It functions like a viral loop. It says others can remix and commercially use your work, but any new derivative work they create must be licensed under the exact same open terms.
Oh, I love that. It forces reciprocal openness. If you build a house using my free bricks, you cannot lock the front door of the house. You have to leave it open for the next person.
This is the exact licensing philosophy that powers Wikipedia. It ensures the commons continuously grows and cannot be enclosed by private corporations.
Okay, so that is the open ecosystem tier. Let's look at a different strategy. Let's call this the artistic integrity tier, the attribution no derivatives license.
This license pivots away from collaboration and focuses purely on distribution. It allows for redistribution, both commercial and non-commercial. People can share it, host it, even sell copies of it. However, the strict condition is that no changes whatsoever can be made to the original work.
You cannot crop it. You cannot apply a filter to it. You cannot overlay text on it. You must pass it along exactly as it was minted.
Why would a designer choose this? Imagine you create a highly polished data visualization detailing climate change statistics. You want that infographic shared globally. You don't care if a newspaper prints it and sells the paper.
Right.
But you absolutely cannot risk someone altering the data points, changing the axis of the graph, or messing with the integrity of your information while still attaching your name to it. BYND protects the purity of the execution.
That makes perfect sense. Now let's look at the third tier, which is where most freelancers operate when dealing with open source. The commercial wall tier. Attribution non-commercial, and its stricter sibling, non-commercial share alike.
The name explicitly defines the boundary. Others can remix, tweak, and build upon your work, and they must give you credit, but they absolutely cannot use it for commercial purposes.
It creates a bifurcated two-tier market. A design student in London can download my 3D environment asset, modify the lighting, and use it in their university portfolio for free. But if an indie game studio wants to use that same modified asset in a game they are selling on Steam for $15, they hit a legal brick wall.
Exactly.
They cannot use the CC license. They have to email me, negotiate a traditional transfer rights contract, and pay a licensing fee.
It allows you to support the community while still defending your primary revenue streams.
Which brings us to the final license, the most locked down version of Creative Commons, attribution non-commercial, no derivatives. I want to spend some time here because on the surface, it just seems useless. You can't change the work and you can't make money off it. You can only share it exactly as is for free with credit. If I'm a working professional, why would I ever release my art under this hyper-restrictive license?
The strategic value of this license can be summarized in 2 words: free advertising.
Elaborate on that. How does a restrictive legal license generate advertising?
You have to look at how the modern internet actually functions. It runs on aggregation. Blogs, Pinterest boards, mood board algorithms, social media influencers, they all constantly need high-quality visual content to feed their audiences. But major platforms are increasingly terrified of copyright strikes.
True, the takedowns are brutal.
If you lock your portfolio behind traditional all rights reserved copyright, Aggregators will hesitate to feature your work because they fear a takedown notice or a lawsuit.
Right, I've created legal friction that stops my work from going viral.
But if you stamp a spectacular piece of typography or a stunning 3D render with a CC BY NC ND license, you are actively removing that friction. You are broadcasting to the entire internet. Please take this file, host it on your server, put it on your blog, feature it on your Instagram.
I am giving them legal immunity to distribute my work.
Exactly. But because they cannot change it, your artistic vision remains completely uncompromised. Because they cannot sell it, your market value isn't undercut. And because they must attribute it, every single time that image is reblogged or pinned, it acts as a legally mandated billboard pointing directly back to your professional portfolio.
It is a top-of-funnel marketing strategy disguised as a legal license. If an art director at a massive ad agency sees my image going viral on a design blog, and they want to use my style for a global campaign, the CC license prevents them from just taking it. They still have to track me down and hire me. We are weaponizing the sharing economy to build brand awareness while keeping our commercial rights perfectly secure.
It perfectly demonstrates that copyright isn't just a defensive shield. It is an active, calibrable tool for career growth.
Okay, we have covered immense ground today. We started at the absolute definition of exclusivity. We navigated the difference between protecting the art versus protecting the brand identity. We broke down the vital importance of the copyright and registered symbols, the strategic necessity of federal registration, the real estate mechanics of transfer rights, and the viral marketing power of Creative Commons.
It's a lot to process.
But theory is useless without execution. Let's make sure you, the listener, have the actionable resources you need to actually implement this armor.
Grounding this in reality is essential because making a mistake on a federal application can cost you thousands of dollars and permanently damage your brand.
First and foremost, what is the ultimate industry recommendation when a designer is dealing with high-stakes intellectual property?
While it is not strictly required by law to have representation to file an application, industry standard practice strongly dictates utilizing a private trademark or intellectual property attorney.
Makes sense.
This is especially true for trademarks. The legal test of what constitutes a confusingly similar mark is highly subjective and based on decades of complex case law. A professional attorney will run comprehensive clearance searches before you apply, saving you from spending a year and thousands of dollars on an application that is destined to be rejected or challenged by a larger corporation.
But let's be realistic about our audience here. A 23-year-old freelance designer just trying to protect their first independent logo design does not have a $5,000 retainer budget for a boutique IP firm. What free or low-cost resources exist to bridge that gap?
The industry relies heavily on two specific avenues. The first is for the do-it-yourself approach. Nolo, you can find them at nolo.com. It is an extensive online library of highly vetted DIY legal books, forms, and software specifically designed to translate complex legal processes into plain English.
Oh, that's incredibly helpful.
It is the best starting point for drafting basic freelance contracts or understanding the mechanics of a copyright application.
And what if a designer finds themselves in actual legal trouble? What if a corporation steals their work and sends them a threatening cease and desist just to bully them into silence?
Then you need to immediately look up Volunteer Lawyers for the Arts. Their website is vlaney.org. While they're based in New York, they offer volunteer, pro bono legal services to individual artists and arts organizations nationwide. They exist specifically to level the playing field. They ensure that creative professionals who lack massive financial resources still have access to aggressive, top-tier legal defense.
That is an unbelievable lifeline. Write that down right now, vlaney.org. Keep it bookmarked. Now, speaking of essential resources, the foundation of every single concept, definition, and standard we unpack today comes directly from a text that I genuinely believe is mandatory reading for this profession.
It really is a comprehensive operational manual.
Yeah.
It covers everything from grid systems and color profiles to the exact legal standards we just discussed.
I'm going to give you the exact details right now so you can add it to your studio library. The book is called The Graphic Design Reference Plus Specification Book. You need this sitting on your desk. And to make it as frictionless as possible, I am going to share the direct Amazon link right now. It is https://amzn.24bybob. I will say that one more time. https://amzn.24bybob. I will say that one more time. https://amzn.24bybob. But you don't even need to memorize that. Listen to me carefully. You can easily buy the book right now by just scanning the QR code of the book link provided in the description below. Just open your phone camera, scan the code in the show notes, and it will take you directly to the page.
Having physical, dog-eared reference material is invaluable when you're on a tight deadline or staring down a confusing client contract. You don't want to be guessing about legal standards when money is on the line.
Absolutely. Okay, let's pull all of this together. Let's synthesize the absolute core takeaway for you, the listener who has been tracking with us for this deep dive. What is the ultimate paradigm shift we are trying to achieve today?
The shift is entirely psychological. Far too many young creatives suffer from imposter syndrome when it comes to the business side of their craft. They feel that asserting their legal rights, asking for a specific transfer lease, or adding a copyright symbol to an invoice makes them seem difficult, demanding, or uncooperative. They are terrified of scaring away the client. But the reality of the commercial market is the exact opposite.
Yes. Asking for clarity on rates doesn't make you difficult, it makes you a professional. When you casually explain to a client that they are purchasing one-time promotional rights rather than a full buyout, you instantly signal to them that you understand the immense value of your own work. You transition from being a subordinate pixel pusher to being a peer, a business owner negotiating an asset transfer.
You command respect by demonstrating competence. You transition from being vulnerable and exposed to being legally armored and strategically protected.
But before we completely sign off, I want to leave you, the listener, with the final, slightly provocative thought. Something to debate with your studio mates that builds on the rigid rules we learned today, but pushes us out into the terrifying gray areas of modern reality.
Oh, because while the federal statutes try to be black and white, the actual practice of creating art is entirely gray.
Exactly. In the very beginning of this deep dive, we established a firm, unyielding rule. You cannot copyright an idea. You can only copyright the specific, tangible execution of that idea. We use the cyberpunk detective example.
Right. The concept is free, the specific vector file is protected.
But what does that legal distinction actually mean for the concept of style or vibe? Because as a mature designer, your most valuable asset isn't a single file, it is your specific aesthetic lens. It's the distinct way you handle typography, your signature approach to lighting, your specific retro textures.
That is the existential question facing the industry right now. Style is not an execution. Legally speaking, style is a methodology, is an overarching idea.
Which means it is fundamentally unprotected. And we are seeing the catastrophic results of this in the era of generative AI. Models like Midjourney or DALL-E are trained on billions of copyrighted images. They algorithmically strip away your specific execution. They aren't copy-pasting your exact pixels, but they map the statistical likelihood of your aesthetic. They learn how to perfectly replicate your vibe.
And then a client who cannot afford your day rate prompts the AI to generate a brand new image in the exact style of your portfolio.
Legally, based on current interpretations of the law, if the AI didn't output a substantially similar copy of a specific registered file, it is merely drawing inspiration from an unprotectable idea. But professionally, ethically, and financially, it feels like absolute theft. It is the systemic strip mining of a creator's life work. Where is the line between inspiration and infringement when a machine can perfectly mimic the ghost in the machine?
It is a massive, highly controversial gray area that the courts will be fighting over for the next decade. And it highlights the ultimate limitation of legal armor. Copyright protects what you did yesterday.
Yeah.
It cannot protect the methodology of how your brain works.
And that is the challenge I want to leave you with. The legal framework forces every single creative to continuously innovate. Because the harsh reality is, competitors, algorithms, and prompt engineers can easily mimic what you made last year. They can steal your color palettes and appropriate your aesthetic vibe, but they cannot copyright the human mind that will conceptualize tomorrow's breakthrough.
Exactly.
The armor we built today secures your past output and guarantees you get paid for your labor, but your ultimate unassailable protection is your relentless, continuous evolution. Keep exploring that line between style and execution. Keep building the fortress around your assets, but never forget that you are the architect charting the course. Keep creating.
Well said.
Thanks for diving deep with us today. We'll see you next time.